towards the end of the session. So there were 3 related readings that you were sent. A couple that dealt with a particular model to try to blend psychology and law to assess them, and then an empirical study looking at responses, in this case of a particular police sample, about workplace psychological injuries arising from different contexts. So I hope you've all had a chance to look at those, because I'm not actually going to be summarizing that material for you today, but we'll hope that you will ask questions about or comment on those readings in the course of today's lecture. Before we get going with the substance, I just want to follow up a little on yesterday's presentations and let you know that I am hoping that all of the spokespersons for the various groups will just send through to me or to Akshara the summaries that they worked from in order to make their 5-minute presentations. And then once I have those, I'll collate all of that information for the class, and I'll send out an email with some commentary and feedback on the work that you did in class yesterday. Until I get those, I'm not going to have as thorough a database to provide you with that feedback. So please do take care to send them in, and we'll chase those down, and I'll return those to you promptly then. Okay, so without further ado then, I'm going to launch into a discussion about some of the precursors to workplace psychological injuries, and I'm focusing today particularly on sexual harassment as a precursor. And so I wanted to acquaint you with some of the interesting international issues, because this is a widely acknowledged international problem. And so I found, for example, that there was a United Nations Gender Program that had focused on this issue in Pakistan. And if you can have a look at some of the detail there, you'll see that there was somebody who actually worked for the United Nations who made a complaint of sexual harassment by a colleague in the same office. After a while, it was discovered that she wasn't the sole victim, but in fact, you know, there were other subordinates who had been experiencing the same victimization for over 3 years, and then finally there were a total of 12 individuals who jointly brought a case against somebody who you'd have to describe really as a serial harasser in the workplace. And that culminated in a book launch which was entitled Working with Sharks, that perhaps you've heard of or you might be interested in reading. But I think, what was really the underlying message of much of what I wanted to emphasize there is that all of these individuals didn't know that there were others who were being victimized organizationally in the same workplace, and often they simply internalize what is happening to them and think that they're the cause, or there's a problem with them, and go on sort of putting up with a situation that finally was revealed to be anything but their fault. I don't know if you've ever heard of the Slut Book, but this is an international movement that was initiated in Canada back in 2011. And what it was a protest generated by women against all of the excuses that are given blaming women when they are sexually assaulted, particularly excuses blaming them for their attire or for simply, you know, being friendly to male colleagues. And this actually was really initiated after a particular police officer in that community had told them clearly that it was their fault that they were being sexually assaulted because they dressed like sluts. And so women in many communities responded to this, and now it's become an annual event, and we have one in Sydney annually. We have the Slut Walk, where a lot of the women dress up in slutty-looking clothes deliberately to protest this issue and argue that you know, the victimization of women really needs to be addressed from a different angle than from blaming the victim. And so those are some international photographs on it. In Egypt, recently there was a report about a sexual harassment epidemic. And you can see some of the photographs that accompanied that report. What they were arguing was that even, you know, women who were dressed and covered from head to toe had to resort to that, you know, again, this was related to the issue about victim blame. So look at that one quote there that said, even if the girls were dressed respectively, only if they were, then no one would touch them. And again, endorsing this idea that is the way that women dress that makes the guys come on to them, and the girls, you know, came blaming them for wanting it, even women wearing a niqab. So, you know, so these, I mean, the point I'm trying to make is that cross-culturally, there are many of the same arguments made, the same sort of phenomenon has occurred. And one explanation there given by Sodek in the Egyptian context was that, in a way, the men were perhaps trying to equalize the status of women who were educated and employed by forcing this kind of sexual confrontation upon them. That it had a lot to do with gender shifts and gender equity changes. There have also been many social satires, cartoons, addressing this issue from a somewhat more humorous perspective. And so you can see here, you know, that there was a whole TV show, you know, about the sexual harassment panda that went on for years. I don't know if it had any traction, it's quite old. You know, arguing that any laws in the workplace to try to regulate this were clearly the fault only of the Democrats, and that laws shouldn't be telling us what we can or cannot say in the workplace, that this was, you know, off limits and the status quo should be allowed to persist. So some of that sort of satire can be helpful in enlightening people about some of the issues. But if you look, you know, largely at this body of law, I think a number of people have regarded the regulations and statutes and legislation that has been imposed on the workplace arena as an area, you know, that might be seen as necessary, but a band-aid rather than particularly effective, and that there has been a large-scale failure because of a number of reasons that are itemized there. And some of those include that there are abuses of the process. You know, so when I worked in the EEO arena, we certainly had what we called the frequent filers, people, you know, who were persistently filing anti-discrimination claims that didn't hold a lot of merit, but were using the process as a mechanism maybe to get at others just because it was legally available to them, and they were bad faith claims. Of course, most of them, you know, just tend to create quite a high workload for judges who have to then dismiss those claims that are not meritorious. So there clearly was some of that foundation. The American Bar Foundation did a number of archival studies looking at complaints of workplace discrimination and harassment in particular. And what they found was quite riveting in terms of the statistics. They found that only a very, very small percentage, 1/20, 5%, of all of the claims that were lodged actually proceeded to trial. And that when they did, plaintiffs' chances of success were exceedingly low. Only 1 in 5 prevailed. When they did prevail, 41% of those claims were in fact reversed on appeal. And lawyers who represented plaintiffs in those cases, when interviewed about them, widely acknowledged that their clients just were not taken seriously. The cases were not taken seriously. And part of the issue was that the plaintiffs lacked credibility. or their credibility was rated low. It wasn't that they were inherently lacking in credibility, but within that system, their credibility was rated low. And that also, for many people who work in that arena, you know, if you knew someone who was one of your nearest and dearest friends or family members who was victimized in that way, the last thing that you would advise them to do would be to pursue formal legal action because of the tremendous social costs, ostracism, isolation, and so on that you tend to suffer once you make those kinds of complaints that far outweigh the benefits of anything you might obtain in terms of legal redress. And of course, I think it's really important to acknowledge that it's not only women who file sexual harassment complaints. The laws are gender neutral in this regard. And there has been a growing and steady number of complaints by male victims. And of course, the victims of harassment can be of the same sex as the perpetrator or of an opposite sex to the perpetrator. One of the most interesting cases that went to the United States Supreme Court is the case of Ankale, who was a male worker who worked on an oil rig, I think out in Texas somewhere, you know, with only other male colleagues. And he was heterosexual, and so were the males who harassed him. It was heterosexual on male sexual harassment. So the question really is interesting as to why he was so victimized. And he was ultimately raped with a bar of soap by a group of colleagues, and very violent sexual harassment that he endured. And what seemed to be a motivating factor there was that he had told his colleagues at work, you know, that, you know, he sometimes went home early and did the shopping so that his wife didn't have to do it, that he was, you know, a helpful husband around the home. And he was perceived not to fit with this very male macho stereotype that was very typical in his workplace. And he was being punished by his co-workers for violating the standard male stereotype that would not engage in those sorts of domestic activities of childcare or sharing the cooking or shopping. So stereotype violations are often a crucial issue, and of course they can be sharpened when there are gender disparities in the workplace, but I think it's really important to step back and realize that this is not just a women's issue, and go forward with that understanding. All right, so in terms of other issues that I wanted to highlight about other communities where legal failures have been documented, and by that I mean the law really isn't providing the redress that you would hope it should provide, or that it's set up to provide in terms of the policy. I have an example here that came out of South Korea, where a victim, in this case a sales clerk working in a golf shop, argued that a male customer took advantage of her by touching her and poking her in her breast area with his finger, and she protested. It was clearly unwelcome touching, because unwelcomeness is one of the criteria for sexual harassment. And the judge dismissed her claim, saying it wasn't actually a sensitive area because it was in the area near her collarbone and not actually on the bosom or the breast. And so a clear sort of misunderstanding that the conduct has to be explicitly sexual in nature in order to be a gender-based violation. The fact, if he'd been aiming at the breast and touched her on the collarbone, it didn't count in this judge's view. It didn't matter what the intent was or what she was being subjected to. Okay. Here's an example out of Russia. And what is sad to see is that in Russia, if you look at all of the sexual harassment cases brought under their existing legislation, over a period of 20 years, a total of 2 complainants prevailed. One in 1993, one in 1997. So such a low success rate. In 2008, there was a female executive who tried to bring a claim. She'd been locked out of her office because she refused to have sexual relations with her boss, who was by many years her senior. And he had demanded that the workers there, he said that they signaled to him, they were using their eyes to cue him that they desperately wanted to have sexual relations on the boardroom table, just as soon as he was ready. And she thought this was a joke. She didn't realize this was a serious comment the first time that he said it. She thought it was a metaphor, but he was serious about it. And the judge said that the employer had acted gallantly, not criminally, by making those comments to her. And then he went on to add that if there was no sexual harassment, we wouldn't have any children in the world. And so that sort of attitude dismissively ended that case. And so, so there is a broad context across many countries showing that even when you have the legislation, it can be quite hard to enforce, quite overburdening on the complainants, and quite difficult to get legal redress. If you have psychological injuries, you don't often get to the point where, after there's a finding of liability, anyone has any interest in what your injuries might have been by that point. And this is just a shot to show you, that people have made television shows about these issues. So this is just a sort of a summary of some of what I call the sexual harassment climate. If we were to take a temperature reading of these issues around the globe, we see commonalities. In China, people are often told not to complain. They stay silent about these issues, or they leave their jobs because they can't complain. Only about a third are willing to report, and this is very common. You find this in many countries. They say, if reporting worked, there wouldn't be so many similar cases among my female colleagues, 1 in 5 of whom reported that they were victims of unwelcome attention. We've talked a little bit about Pakistan, but what the problems seem to be there too is that you just can't talk about it. And people are afraid of negative repercussions, or what we call legal retaliation, being treated worse if you dare voice your concerns about these issues. The Russian favorite form of sexual harassment seems to be what we call sexual coercion, or quid pro quo, where in exchange for sexual favors, people receive workplace benefits. So that's the very traditional, one form of sexual harassment, but there are other forms as well. And the notion that this goes on in universities is also acknowledged, with professors trading sex for particular grades or favors, really undermining notions of gender equality in academia as well. I noted that some years ago when I was searching around, I did find that there was a report by someone by the name of Barkat about sexual harassment in universities in India, where in one survey, at least 76% of the female students reported some version of that, and there was concern that there wasn't really a good complaints process in many academic institutions, so the victims don't know where to turn. They're not sure, because they're not necessarily avenues that are clear about to whom to complain. And if it is your professor, then you don't really have the option of going to your supervisor or your superior with the issue. We've discussed Egypt. I put this slide up here to show you that there's a very long-standing issue. So this is, this was the basis of Victor Hugo's novel, Les Miserables, is really long ago in France, documenting how in Les Miserables, one of the key issues was the sexual harassment, particularly of some of those marginalized women. In South Africa, where I'm from, The Nobel Prize winning novelist, J.M. Coetzee, wrote one of his key novels called Disgrace about university-based sexual harassment. And that's been a growing concern across the globe. I think in the last year in the United States, there's been a repeated set, over the last few years, repeated set of concerns from many campuses about the topic. Very recently, in Australia, literally in the last 4 weeks, most of the universities were responding to release of a documentation from our Human Rights Commission about these issues within academia. And very recently, we had similar releases about harassment ongoing in the military services in Australia as well. So if we step back a moment from just you know, the ubiquity of it and think a bit about some of the legal framing effects, it seems to me that there are sometimes some different outcomes that you get depending on how you address these issues, what the frame is. It seems to me that working from a civil rights kind of standpoint seems to be one of the most unsuccessful approaches to date, because the majority of claimants seem to lose benefits if they engage in that procedure. Going through an occupational health and safety route, by comparison, certainly in the Australian context today, seems to be a far better option, and that has to do with the duty of care that employers are required to provide. But more than that, that now there are some criminal sanctions that attach to that. And that seems to have made the major difference. So just having it as a civil issue alone seems to be fairly powerless. The issue seems to be given much more teeth for enforcement by making it a criminally sanctionable issue in which management of a workplace faces heavy fines or penalties if there isn't strict, swift enforcement of the same anti-discrimination principles, just enforced under a different legal mechanism. So it is quite interesting to consider what's going on here, you know, and I invite you to think about whether that is something to do with psychology of the law and the law in the law, or how do we deal with those kinds of issues. And the fines I've itemized there in Australia. So if you are in management and you fail to fulfill that duty, the first penalty maximum is $550,000 for a corporation. And if it's not a corporation, if it's a smaller employer, then it's far less, it's $55,000. So the fines are adjusted based on the potential economics in the situation as well. There have been a number of developments internationally looking at these kinds of issues and treating this much more, rather than as a civil rights issue, as what I've called a risk management issue within a totally different paradigm, looking far more at the impact of organizational culture that might be tolerant of this kind of behavior that then might contribute to what workers experience. And so that's come along with what I would say is much more growing recognition of the extent of violence in the workplace, which I've listed there, you know, as either staff violence, or, you know, bullying, mobbing, ostracism, different communities that use slightly different language, and certainly it also inside and outside of the workplace can include sexual harassment and sometimes even domestic violence. So this is a scale of risk management, looking at stages, you know, of readiness for change or readiness to adopt policies that are going to be less tolerant of the behaviors, with number 9 being the most developed. So, you know, it's a spectrum of ignoring it or denying it onto sort of confirmation and issues. Number 9 is professionalization, right at the bottom of the slide there. Okay, and this more detailed slide, just gives you, in the next one, some idea about what is meant by each of those terms, and I'll send you all these slides so that you can look through it. But as organizations take their duty of care more seriously to prevent it, then there is much more recognition of the problem and analysis of the pros and cons of different kinds of prevention programs. Going on further up that set of numbers, there might be regular monitoring, regular polling of employees to gather data on it, to assess the risk factors or stop them. And then finally, at number 9, the professionalization, you would have companies that have implemented more of what we call a detailed and sophisticated knowledge of the prevalence of risk factors. And I mentioned one to you earlier on a few days ago. I said if you have a ratio in a department or a workplace where the prevalence of one gender is 15% or smaller and of the other 85 or more, that seems to set up quite make more salient the gender differences in the working group, and that can lead to more hostility between the genders than when there's greater equivalence among people. And in those sorts of programs, some might be specially designed to deal with general level employees, others targeted specifically at supervisors. So in my workplace, as a university faculty member, I have to do online training programs regularly on workplace safety that includes these kinds of issues, and I get a certain time frame in which I can log into a module, complete all of this training information, I have to get a certain number of answers right on a post-review questionnaire and test, and then I'm allowed, to leave the issue alone and move on to other topics. So there's a lot of internal enforcement at supervisory level that might be different as well. And clearly having different channels for people to report, so that there are multiple channels of reporting available for employees who want somewhere to speak about it. Turning to some of the more social, psychological issues related with the phenomenon rather than just legal ones, what has been noted is that there are cultural differences in people's responses and attitudes about the topic, and just their basic perceptions of it. And a very good social psychologist who's done extraordinarily good work cross-nationally as well as within the United States, looking at perpetrator behaviors and so forth, is John Pryor, and you can find him by looking at his site in I think the University of Illinois, I think that some of his work is really outstanding. What we have noted is that there are differences in the likelihood that men and women, for example, in the United States, will look at exactly the same vignette or the same video of behavior or the same description of behavior and rate it as sexual harassment. So the women might regard it more generally, on average, as sexual harassment, and the men might say, oh, this is just somebody being friendly, this is just somebody telling a joke, this isn't really an example of harassment. So there are differences in gender perceptions that have made it clear where there might be gaps. There needs to be more education to bring everyone onto the same level. In Brazil, it turned out that the men were much better at identifying all kinds of instances as sexual harassment than the women. So you can't generalize across all cultures that it's a strict gender issue, and I want to keep emphasizing that there is variability. There were no differences between men and women in some cultures and countries on these same sort of materials in Germany and Australia. But what you do find, where there are sensitivities to perceive it, there might be different notions of what is sexual harassment in those cultures. So in Brazil, they tended to focus much more on scenarios that involve romance, clear sexual interest and attention than in other countries, whereas in the USA, Australia, and Germany, people look much more at things like abuse of power, inequality, unwanted advances that didn't have to have anything at all to do with romance or thwarted romance or rejection, or or consensual relationships, or sexual interest per se. And so that leads us, to take heed that perhaps there are some culturally bound notions about what is encompassed within sexual harassment. Right, so we're going to look at that a little more closely in conjunction with the one reading that I assigned you, where this, what I call the stimulus materials for the study, portray different kinds of workplace events that could be the basis for a workplace injury. And I'll put those up in a moment. But before we go further there, I wanted to make sure that as we turn to focus a little bit more now on just the consequences of workplace harassment of various types, you have a clear understanding of what I mean by psychological injury. Right, so I'm using the word quite advisedly here. I'm not calling these psychiatric injuries, which usually are associated more with a diagnosable condition under the aegis of, some medical treatise that includes, diagnostic and statistical manual or the ICH, and we'll talk quite a bit about those when we do the issues on mental illness and the law coming up pretty soon. I'll go into how you do those kinds of diagnostic issues. You can have situations where very severe diagnosable psychiatric conditions result from workplace harassment, but there are other things that might still be injuries that precede them. So the very severe psychological consequences might include things like post-traumatic stress disorder, chronic depression, suicidal ideation and so forth, which would be diagnosable medically. But I'm also concerned when I talk about psychological injuries about a lot of other symptoms and features that might precede that, which are still compensable under the law. So at the very other end of the spectrum, we have what some of us in the field have called garden variety damages, or the milder versions, from which people might recover quite rapidly, but also are compensable under the law. And those might be dignitary offenses and injuries to your reputation, embarrassment, and humiliation. So they don't necessarily leave you with PTSD, but they're still very uncomfortable and unpleasant, and if you can prove them, compensable under the law. And so in between, there might be a host of other features that we'll talk about as well before you get to those severe disorders. So I want you to understand that there is a very broad spectrum. And of course that's in part because individuals also respond very differentially to the same kinds of events. So it's not a requirement when you bring a case of workplace discrimination that you have any injury at all. Your case can be fully actionable without any injury. But once there is a determination that you have, in fact, had your rights violated or you meet the standards in tort law for a particular violation, then you are entitled to the remedy. And if you then have injuries, the focus is on the nature and extent of any mental harm, suffering, or injury that is caused to a person. And similar to tort law, if there is a pre-existing kind of injury that is exacerbated, of course that itself also can be the basis for, if your functioning is affected by it, of additional compensation. You're not stopped from recovering because you are an eggshell skull kind of complainant. All right, so I've noted that one of the problems is that the courts tend to devalue psychological injury in comparison with physiological injuries, making it very difficult for complainants to proceed on these claims. And it does seem, if we look across the spectrum, that physical injuries by comparison are simply privileged. They're more visible, they're more tangible, they're less likely to be met with skepticism and concern that somebody's making it up and faking it. Other explanations that are given for this disparity in response to physical versus psychological claims is that there's just widespread misperception about them. Or, traditionally in some areas of law, you can only get psychological compensation if it accompanied a physical injury. So only very recently in most legal schemes has it been possible to claim for psychological injuries without, in addition, having some sort of physiological injury as a precursor or prerequisite. So now we have what are regarded as pure psychological injuries, and they can be of many types. So this is a fairly new area of development in the law, although the doctrines have been there for many, many years. And if you looked at the study that I provided for you, you will have seen that the stimulus materials, as I said, highlighted different kinds of injuries. And then what we did in that study was it was a projective sort of study in a way. We asked people to read one of those vignettes. We varied the gender of the target, so half of each version of each vignette had a male target and the other half had a female target. We asked people to imagine and let us know what they thought would be the consequences, how long they would last. Is this the kind of thing that somebody would require medical attention or professional attention if they experienced, including what sort of compensation and so on. So we had quite a fully developed questionnaire. But what I wanted to just dwell on a moment before we go forward are the three types of sexual harassment that are depicted there. So you're very clear that we're not looking only at the very traditional quid pro quo, sexual touching type of romance, which is depicted in the first one. And most commonly we talk about that as sexual coercion. So in our vignette, our target is at work and is approached by a supervisor who touches the target, male or female, in an unsolicited, unwelcome, unappreciated manner. The target protests and rejects those advances, and immediately then that is followed by a threat from the supervisor saying, well, your promotion coming up is going to either be very easy for you or very hard, depending on how you respond. So a clear quid pro quo in regard to the solicitation of submission to sexual conduct. Right, so that's usually what people think sexual harassment is all about. But the doctrines in the law have evolved beyond that, and that's really what was initially covered by the law. So now we address the others, and we've learned through statistical analyses done by the American Bar Foundation and the EEOCs and other bodies that in fact some of these other forms are more common. And also, if you will have looked at some of the readings, very likely to produce just as severe psychological consequences. So the second kind there that we delineated was unwelcome sexual attention. And that's where there's no, the person who's the harasser here doesn't have the power to confer any benefit in exchange for submission to any sexual behavior. So it's simply a situation where you might regard this more as kind of a romance gone wrong, as one way of looking at it, where somebody makes sexual approaches and is rejected, and they might include unwelcome touching. But after the rejection occurs, the individual who's the harasser persists, whether the harasser is a female or a male. They don't give up, and despite the protests, they continue. And the continuance in many cases can include, full-blown stalking that can go on, these days via telephone with lots of text messages. It can include physiological stalking where people are literally followed everywhere. It can include people showing up in your home or your workplace uninvited because of a kind of obsession with an individual and an inability to respond to the message clearly given of lack of interest. Right? So people don't usually have too much trouble understanding that as sexual harassment, but part of what can get confusing to people there is that there's not necessarily clear sexual contact. So the unwelcome touching might be like that Korean case, and that doesn't matter under the law at all. It doesn't matter if somebody just brushes your finger. The issue is what's the nature of it, the intent, the interpretation. I think I once saw a case where somebody had swept a broom across somebody's toes, and that was done sufficiently, that kind of conduct. I mean, yes, it sounds funny, but that was the issue, that was the mechanism, and so forth. And then the third kind is the kind that is usually the least well understood, which we call gender-based hostility, which often has to do with situations where a workplace that has been dominated by one gender, such as nursing, which is very female-dominated traditionally, has members of the other gender moving in, and then there's a conflict over people seeing their traditional turf or territory being invaded by members of the other gender in smaller numbers initially. That is met with resistance that can be ultimately physical, but usually starts off with jokes, but not pleasant jokes, and often includes very nasty gender-based comments, and all sorts of behaviors in between, such as spying on people in the toilet, etc. All sorts of gender-oriented issues focusing on the difference between genders, usually associated with many of those stereotypes that I've mentioned as well. And in our vignette there, we made sure that the supervisor was aware that the target had complained of these harassing comments and that they might have been made in the presence of the supervisor, but nothing was flagged as inappropriate. And if it's not flagged by management as inappropriate, often it continues. Right, so that was contrasted in the study with a situation of co-worker hostility that was entirely unrelated to gender or non-sexual in any form, simply based on being assigned extra work and the threat to write somebody up for failure to meet deadlines, which of course can be very stressful and of course does occur. I'm not suggesting that because this is not a sexual harassment vignette that it's not a serious one. We were just trying to compare how our research participants would rank the one versus the other. Would this seem more serious than some of the others, which under the anti-discrimination law are also serious. And then we finally had as a control group, really, a physical injury vignette where somebody gets injured, because of inattention to a potential danger with an unstable ladder, and probably has pain and suffering in addition to the physical injury. So that was the basis for the study, and I'm just highlighting those sources because I want you to understand what the precursors might be for psychological injuries from any of those that we're going to talk about. Okay, so I think at this point, what I want to do is just sort of summarize what I think the key points were to come out of all of the readings and this introduction that I've provided elaborating on workplace harassment, and that is that I think the focus from the empirical legal studies and law and psychology standpoint is really much to see that there is an interactive environment here that needs to be addressed, that includes the context or the workplace, if it's at work, you know, the target and the harasser, to underpin that the nature and scope of injuries flowing from those events can take time to develop and accumulate, but because they're invisible, they might be hard to discern. And so really the other readings that I gave you in the book chapter what else? There was an article from the journal on psychological injuries. We're focusing on a model to try to help to systematize ways to capture the nature and scope of those injuries so that they don't seem so elusive and invisible and intangible. In this area, very clearly, drawing on all of those legal failures that I've highlighted, issues about credibility of the parties, you can tell, especially the claimants, are going to be paramount. And so you need to consider what other sources there are of information in addition to and surrounding the complainant's own statement. And that's why there were discussions about collateral sources, evidence from other witnesses, evidence from records, you know, and so on that might help to document it. And of course, the primary legal issue is going to be the issue of causation, and particularly if you're in total proximal causation. And so how do you meet that threshold when our lives are just not as, you know, compartmentalized as the law would like us to have. And so all of us at any one time have many things going on, and there might be multiple sources of injury, some very historical in someone's life, some very contemporary, you know, and differential resilience in different ways. So if you find that you have a complainant who has had a prior workplace issue and injury, or a complainant, you know, who's currently undergoing a very traumatic event in their family, with death of a family member or marital dissolution at the same time, in the same time frame as alleged harassment, how do you tease apart the relative contributions and find the causation that might be attributable to the workplace events in issue versus some of those other intervening events? You know, do you have to just throw up your hands and say we can't do it, or is there some way that someone can work through that and deal with the causation issue? So that's what those other two readings were very clearly to address. So in that, we're looking at the consequences and the causation, and to highlight the consequences that are documented, I provided in those readings a number of tables that summarize the results of a series of meta-analyses. So I hope you saw those. And along with those were all of the kinds of symptoms that are associated with these sorts of injuries, because there are differences in individuals. And so you'll see that, you know, for some people, they turn to self-medication, they end up having alcohol problems or drug problems. Other people do a lot more of what we call somatization, and that's much more in certain cultures where you don't have so much ease about talking about your mental pain and suffering. You say rather, you know, that you've got a headache rather than that you're in mental anguish. You turn it into something physical. You say, I have a stomach ache or a headache or, you know, a lot of bodily tension, because that's perhaps more acceptable in your culture than some of the abstract things. So that table shows some of the studies done in different places that would pick up on all of those different dimensions. So that's very key in terms of looking at the outcomes. All right, so in working through the task, if psychology and law are going to collaborate to make improvements in this area of law to try to reverse some of these judicial failures or legal failures. That's the challenge. And it's as much of a challenge in the Australian legal community as it is in any other. But I think that it seemed to us that by the collaboration of lawyer and psychology together, we were able to make some advances on that. And my major collaborator in the work that I've done on that area is a clinical psychologist who lives in Albuquerque, New Mexico. We have collaborated long distance now for many years on that line of work. And our most current project is to try to really flesh out more of a continuum between sexual harassment and sexual assault, looking at some of these components. So it's been an ongoing type of collaboration for the two of us that covered that ground with that model after working on some other pieces before. So I've enjoyed working with Bill on those issues very much. And he really does sort of specialize more in providing expert evidence on a range of cases to do with psychological injuries. But what you have to do, whether you're the lawyer or whether you're the psychologist addressing these issues, is develop hypotheses about the causation and test them rigorously. And so I want to hear some of your discussion about that. But what we essentially offered in those readings was just a tool to assist people in grappling with these issues that blended some of the knowledge from the law and psychology. Okay, so I think I'm going to mostly rest there and jump to some of the concerns that I want to have members in the class address in trying to extend these issues more to your local context. And we've been focusing on some legislation. We've been focusing, which might be anti-discrimination schemes or other victims' comp schemes. We've been focusing along the way on some kinds of cases and some of the procedures available for people to use to get redress. And I also, given the changes and the shift towards more of a risk management approach, wanted to give some consideration as well to areas where there might be corporate liability, criminal or civil, for these kinds of injuries in the workplace. And so in advance of this class, a few of you have kindly undertaken to briefly look at some of those issues, and I'm going to give some of your class members a chance now to come up and talk through some of those local context issues. And maybe we'll start with a little bit of a review about one aspect of whether there is any legislation that could be considered in your legal context on those issues.
Before we get to the legislation part, and the fact that you've spoken about the sexualized and the non-sexualized kind of, the continuum that you spoke about in that particular slide which had all of those. I was kind of like, say, if you look at the number 3, when you talk about a hostile environment, and as to be seen, what is seen as what is seen as toxicity, what would you be seeing as misogyny, what is acceptable and not acceptable, the gender hostility part, and who kinds of sees this as hostile, and how the other kind of presents it as norm. But this is, just being oversensitive, it is just people having fun, or why is everything made into a battle of the sexes, so to say? I mean, it's very often gender hostility gets received when you're protesting against it. Unwelcome sexual attention as well as sexual coercion is more an individual person kind of being on the receiving end of unwelcome attention. So as your study also demonstrates, people find that easier to comprehend as within the realm of harassment. But if you recognize it, it's the gender hostility and the fact that one particular mode of conduct is seen as okay by a fair number of people, which then allows for 1 and 2 to happen that much more easily. That's what kinds of makes the power equation as unequal as it is. And I was, from there, my loud thinking, and I felt that before we sort of straight go into legislation or case law, or how compensation is addressed and stuff, are these not more largely discourse issues, questions that you as a society and as a community need to be asked more sharply? Because the moment we transpose them into legislation and definitions, then the point that you are making about if this is psychological injury, then is this injury caused by that conduct, or is it that you're just one hypersensitive person? The moment somebody raises their voice, something happens to you. You know, those kinds, so the entire thing gets trivialized into that individual person's cause of action. And we don't really discuss what makes for a productive workplace or an equitable workplace or a healthy workplace, and healthy in just that everybody can subsist there without feeling cornered. And so I'm just wondering, and I do wonder if you could spend a little time around it, that as law people, when we sort of translate or transpose social interaction questions into legal questions at once, do we lose something in that conversion? And what is it that we lose? And is it like that the moment we lose it, is it no possible? Because if I'm not addressing it as a culpability question, but more as a social discourse and a social communication and interaction question, is there something I'm gaining there? And are there more negotiation possibilities? Or is it that the dynamics is so inequitable that without the law entering, we can't do very much? I'm sort of, I wonder whether I'm getting through, but I really do think that if we are speaking in terms of sexual hostility, and I'm not speaking about only, you know, the expectations from what is expected, what say women may be expecting from, but I'm saying either gender, the way in which you look at people who don't possibly conform to your stereotypes. The example you gave us of that man who did shopping for his wife and consequently kind of transgressed the macho culture. So what then happened? What is the kind of joking which is acceptable? I'm not sort of speaking in terms of, you know, obliterating humor from how we are interacting with each other. But I think generally I would say humor is something which much more should be self-directed. Targeting is what you do when you pick up minority people and you sort of, those distinctions and the absence of conversations around them. So I was wondering, you know, Jane, if little bit time, if we spend at least thinking aloud about it and then looked at, okay, what are we expecting from the law and how much of it is the law capable of delivering? Because if you're speaking about a continuum, and law generally revels in very well-defined, you know, categories and classifications, and then all the time and energy is spent on whether you come within it or you don't come within it. And if you don't come within it, then it's okay. I mean, if I hit the collarbone while I was hitting the breast, collarbone is not a sexualized part of the body, so it is not sexual harassment. That's a kind of thing which is a very legal consequence. And people who are kind of the gatekeepers of the law feel that is their obligation to do. So, in the realm of psychological injury, I'm just wondering whether, I mean, it's a long question that I keep on asking again and again, but I'm hoping that
No, I just wanted to respond from a practitioner's experience. It is very interesting when you say that there is sort of gatekeepers to the law and the limits to what the law can do. If you look at the litigation situation in Delhi, for example, very few officers would come within the ambit of the Sexual Harassment Act, and very frequently we have offices where you have enormous disparities in gender. So you have one female colleague with, let's say, 4 other male colleagues, and then it becomes very difficult if there is a culture which is gender hostile. I have had numerous friends from my college, from my batch, who work in various chambers in Delhi and have faced sexual harassment in office, in court, on the way. And I don't know, at least I'm personally very skeptical about whether law can do anything to address that. It is very much more a awareness question of, firstly, like you said, the management should be firstly aware that such things are happening and they should be sensitive to it. For example, in legal settings we have people coming from various different cultures, so you can have, let's say, a senior partner or a senior lawyer who is educated, and then you can have an office boy who is completely uneducated and who's probably almost grown up his entire life in that chamber. And then you can have someone like a clerk who basically helps carrying files and file things in court, who's also usually not very educated. But at least in my personal experience and anecdotally, harassment comes from all three. It is nothing to do with, it is not that the lawyer or the colleague who is educated will have any different notions or will have more evolved notions or will be more sensitive. That is not the case, at least from what I can say anecdotally. The other question that I wanted to discuss generally was not about the sexual harassment, but the non-sexual harassment. At least in the legal circles, there is very much almost pride in this tradition of a senior training his junior through what I would call downright bullying or downright sort of harassment. And like she said, any protest is seen as being weak or being unable to cope or incompetent. So, and a lot of concerns are raised by a lot of junior lawyers about mental health. And if you add to this other factors of economic payment and the conditions in which they live, then that can be a fairly sort of explosive combination, so to say, and can have severe consequences in mental health of lawyers. So I was wondering if others have any views on that. If you went to internships and things and saw what happens there?
No, it's actually sort of somebody saying that if you do not address the structure, most of legislation is the individual. Then is there not kind of somewhere fixing the system in a particular way? That is, I suppose, at very core where my concern is. In your slides, you had this one part where you were speaking in terms of corporate responsibility, possibly like, say, if we're talking about 75% and above harassment by women students in institutions of higher education, if that's the kind of statistics, even if like we, if we, I say if those are the kind of statistics, I think it becomes very critical to then ask, what is the responsibility of universities? If that's the sort of thing which is happening, is the route of filing inquiry, going through an entire investigation, finding people culpable or not culpable, is that the way to address this issue? Because when I'm certain when our colleagues come and give their presentations on legislation, case law and stuff, it's going to go very centric around the fact of what is it an individual victim can ask or not ask for. And if the individual feels that the system is too large and doesn't want to do anything about it, then nothing happens about it. And I think that's very, very important to ask. And I wanted to flag this before we did the legislation, because then you more sharply comprehend that the legislation is trying to give the semblance of a remedy, which is not a remedy. Because the most important thing that is, I mean, we have, Vasanti's been kind enough to come and join us today. Vasanti is heading the cash committee at Nalsar, sort of thing. So I thought that, you know, you need to be somewhere asking this further kind of question, that if only having an, what is it called, an inquiry committee, whatever, internal complaints committee, that is a requirement of the legislation for every institution, not just educational, but even workplace. That is, supposing somebody has a grievance against an individual person, then that internal complaints committee will examine the matter. I'm kind of concerned as we listen to this presentation is that how many, other than creating that internal complaints committee, we don't seem to think of any other way to structurally address this issue. How do you bring a zero tolerance, or at least maybe a 2% tolerance kind of an environment? Though I would say it should be like, it has to be zero tolerance, because anything other than that, anything goes. So that's somewhere I feel, you know, as law people, we very quickly turn into making definitions, legislations, people having grievance redress, and consequently get complicit with this rather than our challenges of it. I mean, that would be my most, we'll say, my position on this entire thing. And I'm hoping that you people would sort of, let's see, somewhere as law people, we are kind of trained to think that if we get legal intervention in place, we have in some very core manner addressed the problem. We don't spend time to think that the problem is there, but is the factor of creating a legal intervention, which has its own limitations, because the moment you're going to charge somebody, then considerations of fair process and all of that come. The moment it is one individual against another individual, side-taking comes, and yet the behavior is unacceptable. So is there a way of addressing it which kinds of can get, you know, not get into this dichotomy and yet say this is unacceptable? So I'm yeah.
Just pass this on. No, whatever you were doing here. I don't know why the hell is the entire class moving that side. I don't think Jane is sitting there. You could have used some of the front seats. I think all backseat people know attendance.
I was just kind of wondering that even if it's not a legal process, the process will end up being individual against, or individual to individual, right? Because some of these things that we were talking about earlier are so subjective to every individual's own perception of whether or not it is hostile, whether or not it's coercive, whether or not it's unwanted or unwelcome. So in terms of creating that, perhaps what I'm saying is that it will end up being an individual against another, right?
No, because if you're talking, if you see the entire set of slides which can I have? Do we have enough time? No, not now. Okay, take it.
If you look at the early slides with which Jane started her presentation, and she took us on a world tour of sexual harassment. And it looks like that's one place, if you want to think in terms of affinity across countries, you can find it here. But you do find, no, I'm just saying is that you talked in terms of, and one running thing somewhere is that if you're making comments in relation to dress, what is acceptable in what one can wear and not wear, the kinds of diminishing, people in. Of course, we're having that Chamachalo controversy where this one, the first court has kind of put the person. Chamak chalo is like a GIAN. It's a sort of, there are various ways and various intonations in which it can be used. It's like in some manner you're talking in terms of somebody who's like flaunting her, whether it is her assets or her beauty or her whatever. That is one way. And it can be said in a complimentary and in an uncomplimentary manner. Both can be complimentary. It has to be necessarily consensual. In the sense if somebody is calling me beautiful and I'm liking to be called beautiful and there is a basic kind of exchange happening, it can be very complimentary. On the other hand, if somebody is making that as an objectifying comment, it can be very uncomplimentary. The person who took this individual to court was where she was traveling with her husband and a third person called her a chamachalu. And that's wherein the court said this is not acceptable. So it's not just in the word, but in the context. What we are talking about, Sarika, is this: if we don't want to make it an individual thing, then it's extremely important that, as I say, a law school, we speak in terms of that what is an acceptable way of speaking with each other. If we are having a freshers party, what is acceptable and what is unacceptable conduct? What is a way of rectifying, say, drunken behavior without us having to file formal complaints? The only way, and that's very much coming up with a set of general guidelines of behavior and how we do it. And to say that if you want to keep saying that it has to happen to you, then you have to raise hand and say, this happened to me. And I have to go through that whole process of recounting what happened to me. Only then can some redress come. That's not addressing it systemically. But if we are all aware of the kinds of conduct which is seen as misogynist or which is seen as, anti-trans or is generally very stereotyping in terms of gender. We're all aware of it. I mean, and if we were to make a list of that and to say that, okay, what is it that we are saying is not? Because just the fact of, I could playfully say anything to you, and if you are liking what I am doing, it's between you and me. And it's nobody else's business. But if I am saying this is not nice and I don't want it, that basic norm of that you then move back, and there's everybody else who tells you that no, you move back. That is not an individual thing. That's about setting up a culture in an institution. And that culture can only happen through discourse like this. It cannot happen through that is the proposition I want to put forth. And I want us to discuss that whole thing of legislation, case law and all that, keeping that in mind. I'm sort of deliberately putting my pole in the middle and saying, no, I mean, we as law people believe we have these great solutions for very social problems or social, you can say, a certain kind of a cultural conduct we have imbibed uncritically. I'm not even finding fault with people. I'm saying is that very often you are told that if you don't do this, you're not a man. You know, it's like what kind of a, if you have seen that Badrinath Ki Dulhaniya, there is this one particular component at which this friend of the hero is telling him, what the blessed hell, she's treating you like dirt, and you're sitting out there and mooning away at her. Why can't, and if either you just dump her, or you kind of like abduct her and take her, there's no third way out. And the entire conversation of the film is on the factor of what nonsense. Neither is an alternative. I'm saying how many discussions of that kind do we openly have? All of our discussions get centered around an individual incident and all around it. And when you focus your attention only on an internal complaints committee, that's what you land up doing. And when you, in a legislation, again, when we focus on causation and credibility in an individual case, we reinforce it. I am not saying that there would not be situations where this is required. I'm saying is that for three, the point which Jane, what you put in terms of workplace hostility, how many interventions which address that structural question, even within the law, because then you speak about that this is what the corporation is in, or the university or the institution or the government office is obligated to do, irrespective of whether an individual complaint happens or doesn't happen. And if they fail to do it, how many of those kinds of situations have really surfaced further? Because it's usually some individual who's required to carry that flag. And whichever way it goes, you may win some, you may lose some. I'm not only that aspect of it. I'm saying is that this discourse and the way it is framed is a fixed discourse. I'm sort of somewhere wanting us to keep that in mind and hope that maybe after
I have a point to make. I'm maybe addressing this structurally. So, I mean, a lot of times people put up with some sort of gender hostility or stereotyping, which they are not pleased with, but they do that to just fit into a certain organization or a structure. So, I mean, I feel that there's a need to address, can we address that through?
No, then it will become like, who should start that discourse? Where is it that it should happen? Do we sort of like, I've been sort of, after poor Vasanti's life, saying that she needs to get a set of guidelines in place. I'm saying those guidelines need to be discussed between us as Nalsarites. I'm deliberately focusing it on, because our university would be exemplifying the same sort of thing. So if we have a set of guidelines, if it is reciprocally settled, if we then say that, okay, anybody who preaches in it, all of us as a university would sort of then not permitted to happen. I'm not even saying causing complaints and stuff. I'm saying that, no, this is just not acceptable. The same thing about what you're saying is too fitted, I tolerate, is if it's too fitted, you can't do. The principle is the same, no? So it is like if you wish to fit in and you behave like that, we all sort of just look at you like this, my God, you talk like that. If the sanction is available, it's available both ways. No? Why is it that it's only available for horrible behavior? That people, the more horribly you behave, there are more people who will say, to fit in, I will tolerate the horrible behavior. Why could it not be the other way? That if you are a practitioner of horrible behavior, I don't even mind, I'm saying that literally looking askance at you, can we be going back and looking at, there were a whole range of community sanctions which operated well. Is it possible to think of those? Because as a way of, and maybe I'm just thinking aloud, but I've gone through these sort of things on an ad nauseam basis, and each time you really don't know, whether, even when you provide somebody relief, is it at what cost? How the entire trauma of going through this kind of, and having everybody to talk about whatever, is not a, see, I'll just give you one before this, I hand in the mic, and I don't want to sort of negate the hard work that my colleagues have done in playing the, what should I say, the game spoiler maybe, but wanting to, we had a case of a senior IPS officer who at a social event, like her bottom was pinched by the guy who was the Inspector General of Police. And she was a really, she was not some clerk there. She was a senior IPS officer, and she really took a front on it. And she sort of filed a case. She lost it in 2 places till she went to the Supreme Court, where they gave her, at least they acknowledged the fact that it was an outraging of modesty or whatever sort of thing. It wasn't that the guy retired with his full this thing, but in court, and the extent, the sort of stuff that she had to go through to sort of, make that case about her own dignity, and to say that what nonsense. His saying, oh, I was just like, pinching bottom of female colleague is like backslapping of male colleague. That was virtually what the particular Inspector General of Police was saying. And she went through all this, and there's a powerful video that came from her more recently, where she said, if I had understood what this was going to be, maybe I would never have filed. And when it went to the apex court also, she was most uncertain whether they will listen to her or they'll accept what she's saying. Because it has to be enormous. Just somebody pinching your bottom once, what's a big deal? The fact that it's negating her entire life work, was not getting the sort of credence. Still, the Supreme Court, it isn't the greatest of judgments, but at least they did some process of recovery from her. So I am saying is that when you have an entire culture embedded against you, though having a legislation which says something in your favor may be useful, is that the route to change? I wonder.
I was just really glad that tied both what comments that came in. Yeah. I was really glad you brought up this whole question of what about harassment and gender, because often, especially in our context, when we speak of sexual harassment, it is not gender neutral. So not only does is it unfair to men who get harassed, but it completely negates the possibility of, well, people who do not identify with gender binaries being able to complain, and they're probably the most harassed in workplaces when they get access to workplaces at all. But I was wondering if it's possible to think in terms of using the law to make neutral norms, which is possibly easier to digest even within implementation sort of settings, because the moment you create gendered norms that are supposed to address historical injustice or do it in the context of race or whatever else, there's this immediate idea that this is reverse discrimination, and language of that sort starts to come in. Things are always in favor of women, not this is against men, this is trying to, the moment an intern files a complaint against somebody she interned with, you have lawyers saying we're not taking female interns anymore because we don't know what they're going to do, we don't know what behavior is okay with them. So I was wondering whether it's possible to think in terms of constructing in the law neutral norms that are inclusive and speak to different sorts of experiences, whether it is harassment in the way in which ragging, but outside of the college setting, so to say, or harassment in the workplace, but address structural injustice discursively. Is there a way to recognize the fact that sexual harassment occurs and it happens very often to women, and this is because of patriarchy, but not necessarily, and that there should be legal remedy available to a woman who has been harassed. But does that remedy have to be named in a gendered manner? Is it possible to construct that remedy in a more inclusive sort of way that speaks to a larger, more diverse set of experiences and identities? It was just something I was thinking.
Sure, thank you. I'm a bit confused by some of your questions because I think the law is framed that way. So that's what I need you to unpack a bit more for me. I mean, as far as my sort of experience of all of the legislation is that there is nothing particularly gendered about either the remedy provisions or about the liability provisions. So I'm not quite sure what you're referring to.
No, that depends, I suppose, from setting to setting. So in most spaces, sexual harassment norms are gendered. Yeah, I'm saying I presume that differs from the jurisdiction in question. So in most institutions that create their own complaints committees and so on, norms are gendered. And in several countries too, they are gendered. So I was speaking from that context.
Okay, yeah, certainly the legislation in Australia and in the US, just speaks about workplace harassment, and then if there's a subversion of that is gender-based, it doesn't make any reference to male or female. It should be inclusive of claims that are brought, regardless of the particular worker's gender or or who's doing the harassing, you know. So a lot of those provisions, for example, you know, have applied. I mean, I think we had lots of cases brought about HIV discrimination that fitted within those if they were, you know, related to gender. That was non-specific, you know, and clearly are available to both men and women, regardless of who the harasser was or the circumstance. And also workplace hostility, as you were discussing in terms of more of the bullying force. You know, most countries have adopted those sorts of provisions as well, which are sometimes good substitutes for harassment kinds of claims, irrespective of the origin of it or the specific substance of what the behavioral comments might be. But you know, I'm certainly in full agreement with you that they ought to be accessible to any worker who is subjected to any kind of hostility because of anything to do with their individual characteristics or those in contrast with the others. I wanted to respond a little bit to some of the issues about broader social values or norms and concerns outside of the law, and say that what is interesting to me, at least as a psychologist, to look at this arena is to acknowledge that most of the research that has been done on harassment has been done completely independent of the legal stratosphere, without much connection, in fact, with the law. And so most of what we know about people's behaviors and responses to harassment has been conducted by researchers working outside of a legal context, outside of the legal structure. And there are quite a number of, you know, scales of measurement indicating you know, that structures that have been created, such as rape myth acceptance, or the extent to which violence against women or any individual is endorsed, might lead to a greater likelihood for harassment to occur. So that seems to be at least a mindset in some communities that is stronger or weaker, that provides a great propensity for those sorts of social phenomena to occur. So broadly, a lot of the research, if you look at it, and I think that Bill and I summarized most of what was available, you know, up till about 2005 in our first book on sexual harassment in general, really comes from a body of work totally independent of the law, which might be more valuable to address the kinds of questions that you're asking about what are the social norms, and you know, and clearly where there are attitudes that are you know, patronizing in some fashion, that leads to just as much inequity as hostility. So, you know, there's sort of a benign hostility as well as more violent hostility that can be the basis that generates an uncomfortable environment for people. And there are psychological scales that do address those as well, that underpin a lot of that work that has been done. In terms of specifically where to look from the psychological arena for redress mechanisms, it's really the field of organizational psychology or workplace psychology that has done the most valuable work in that regard. And you know, and my own focus today was not so much on the liability issues or the management issues, but I'm very delighted that those are being raised as the sort of foreground or background fundament for that. Out of some of that work has come important findings showing that really endorsement by upper level of management is probably the most key ingredient to generating some sort of change in workplace culture that can be positive. And it has to be instrumental, you know, and visible. So it can't just be adoption of a no tolerance policy. That alone, you know, is usually a piece of paper that sits in a drawer somewhere in someone's office, and there's not going to be any basis for people to model behavior and emulate behavior and indicate with regard what is acceptable or what is not acceptable. So at the upper levels of management, whatever the size of the institution, there needs to be very clear articulation, action, endorsement of what sort of values in the workplace are going to be tolerated. If that doesn't happen, what tends to occur is that the acquiescence or tolerance is then imputed, and that creates a very ambiguous kind of culture in which it has been shown all sorts of other infractions that go on then become the norm themselves. You know, so that is probably the most key message that is responsive to the concern about what should happen within a workplace or an organization. So it clearly policies aren't enough. You know, and usually that has to be accompanied by lots of modeling and training and making more visible some of these processes, including outcomes of investigations if they do occur, which are often just conducted in secret and buried because companies or workplaces are embarrassed to have those things go on. They're not necessarily thrilled to have to disclose that information. So while on one hand it's really unfortunate for the complainants, if they suffer as a result of things becoming public, it's important for their confidentiality to be preserved. There ought to be ways that the incidence or the prevalence of these things in organizations is made more transparent without necessarily placing the identity of those individuals at risk. Anyone who's worked in litigation in this area knows that the immediate unfortunate thing that happens to the complainant or plaintiff is that their lives are trashed from end to end, and that is, that is why it is so difficult to survive being a plaintiff in these cases, because the defense is usually to rip apart every aspect of your competency and try to paint you as incompetent, oversensitive, etc. As you've indicated, that's very standard. So the judiciary and others can intervene to sort of change the acceptability of those defenses as well. There is work to be done there in terms of accepting that. Go ahead.
Trying to connect to what Dhanda ma'am was trying to put through in the class, I think a discussion also, and I've been thinking about this lately, how this legal process seems to be incomplete in getting back the status quo for the perpetrator in this case, in these cases.
For the perpetrator?
No, I'm sorry, for the victim, yeah. So a discussion, the lack of discussion or the lack of the kind of understanding that ma'am was promoting, I think a discussion also needs to happen as to how to deal with the perpetrator in this case. In the sense that how the friends of the perpetrator should act after they know that something has been done by them, or how, after the legal process, the legal or the administrative process is complete and a certain sanction is given, how people around the perpetrator should deal with this. And I also had my doubts with, how, in the sense that how should I or someone else should act in this situation where they know someone has done something. And that is why I feel the process, I'm trying to add on here, that how this process seems to be incomplete even for the person, where the person is unable to understand how should he get back his life. No, because I work on the premise that social integration is the way to go even for the perpetrator here. like in the end, he also has to be integrated back to the normal. But how to do that and the way to go about it is something that is not discussed, and again, like, and obviously the remedies are not enough to address this situation. So if Vasanti ma'am or Nanda ma'am would, and Jane ma'am would want to talk about this a bit, I would.
I'm going to grab the mic for a second and just say that what I was reminded of while you were commenting there about perpetrators was what we've just experienced in Australia with our Royal Commission into Institutional Child Sexual Abuse, which typically affects male victims who don't come forward at all about their experiences until their lives fall apart 20 or 30 years later. And what we had transpire in the past year was mainly a series of actions against very well protected religious institutions, where these cases were covered up through internal investigations over decades by various churches, including the Catholic Church. And what our Royal Commission did eventually was take the deposition of Cardinal Pell. And now he has been criminally indicted by the prosecutors in the state of Victoria for his role in knowing about information where there was, sexual assault and sexual abuse of young boys by a host of various priests within the Catholic Church. So it was just simply kept under the rug. And so the point I'm making really is that I think sometimes some institutional accountability through this mechanism, in this case a commission, not a court, but ultimately has led to legal proceedings in the regular traditional channels, has been pivotal really in providing redress for a whole series of victims who hitherto had no voice at all and no redress, years of and having nobody believe anything that they said. So that's one side of it. I mean, of course, I do think that it is important to reintegrate people into the community, and when we come to talk about sentencing, I will be talking about a special program of keeping child sex offenders in the community that I think is very valuable, as a model. So I think there are ways to do these sorts of things. Let others add some comments, and then perhaps we need to let some of the people who've got a few comments about some of the legislation and so on come up. There are a few more comments. Yes, yeah, go ahead.
Just a couple of comments. One is on this idea of gender hostility, and I think if I can tie it to what Nitanda was saying, I think the question is also in the absence of a larger framework dealing with discrimination. I think that's where your confusion also is coming. Because if you have a larger framework dealing with discrimination, and sexual harassment is set in that larger framework, it becomes a part of the other forms of behavior, which are also seen as problematic. But I think the Indian context has largely been that we've somewhere isolated just sexual harassment from the other forms of harassment which happen, the other forms of discrimination that occur. And we don't have any mechanisms to deal with that larger problem, whether it's the workplace or it's in institutions or generally. And that has been the singular largest problem, which I think will be very evident once the others make their presentation in the Indian position. But the question of, if I understood that correctly, that if you don't want to call it sexual harassment and so then use it to address perhaps a larger range of issues, which is what perhaps my friend there also was saying, that you're trying to address a larger range of questions, which an instrument which is very limited. Then that's where the problem comes, because then you're trying to address a whole range of harassment which others call as moral harassment or other forms of discrimination. You begin to try and address all of those with that limited instrument that you have, which is the sexual harassment law. Then the question of fitting all of these cases into that is equally problematic. And I completely take the point that if you're trying to then address it through an institutional mechanism without addressing the structural questions, and perhaps I would want to hear you on that, how does the law, is there any law that is capable of addressing the structural questions which is not largely in terms of an individual complaint? I mean, is there a process which can happen by law? I understand the organizations can have policies, organizations can develop code of conduct, they could talk about guidelines, as Vijayanta was saying. But is it possible through law to, for example, as we were saying, that can we actually ask people to behave in a certain way through the law? Or is that definitely one of the limitations of law that we then have to work with?
Okay, I suppose in response to the point you're making, Kushal, one of the things, in fact, what I am trying to sidestep, let's say, is that instead of you talking in terms of that's where I'm coming from, that instead of starting your discussion around and at the time when a specific act happens, and hence we are all required to take positions one or the other way, to be with friend or not to be with friend, what am I supposed to be doing, is this wrong or not? I'm saying is that why is it that each time all of our discussions happen when something which we consider to be not right happens? I'm sort of putting forth that where is it, and wherein to say, oh, we can do it only because after all, if institutions make their set of regulations, that's law. That's law for that particular institution. At the meta level, I would say all institutions should at least, even if it's an obligation placed on you, on the top management, to see that this kind of harassing conduct, whether of the sexualized or the non-sexualized kind, does not happen. I think just that much is sufficient then for each side to be starting to devise it. As a law school, more than any other place, for us to engage with this question and to say, what is it? We've seen the Internal Complaints Committee function for a fair amount of time, both in our institution and other institutions, as well as what has happened in courts. What are our big gains there? Have we really been able to generate a discourse of what would make for a non-toxic, developing, growing, happy environment? Have we had a work environment? Has any one of those particular cases ever had a conversation around it? No. It's only about complicity and not, what am I supposed to, I'm supposed to hang this person like a specimen and make him an object for? Or is it like going to be making for some kind of, like basic norms of what is socially desirable, undesirable, morally right, legally required? None of those conversations happen. That was the larger point I was making. And I'm sort of saying each time when we say it like this, it becomes like a man versus woman, irrespective of, because largely, though nobody is denying the question of, the sort of oppression that is experienced by trans people, people who do not identify within a specific sexual stereotype. I'm saying if unless and until you begin that conversation, the other things also won't come. I'm only saying is each time we begin that conversation and we move around it, only around this business of who should we hang and who we should not. I'm saying is, why can't we have this as a constructive conversation on? Now, it's not like what behavior you should do, but at least what behavior you should not do. This is not an acceptable thing. This is a kind of conduct which any civilized place cannot happen. And if we start that, and then the point you're making, Jane, that it becomes that if you do that entire process, then it is the absolute obligation of the top management, whoever is supposed to be in charge of all of this, to see that it doesn't happen. And any conduct which happens, you don't wait for complaints. You so want to act because it is your obligation to do so. And that's a way better way of starting to make for a zero tolerance environment on some sort of conduct. That's the point I was trying to make. I'm not trying to say that, okay, you pin this one and you exonerate the other. I'm saying you create an environment where this kind of thing is, as a community, not acceptable. Akshara was talking about the fact of that this is what, as a community, is practiced, and hence anybody who doesn't like it doesn't belong. So if as a